Home buyers have rights too, and contracts matter. This was the message handed down by the Ontario Superior Court of Justice this month, in a case which awarded a potential homebuyer almost $10,000 in damages after the seller failed to complete the agreement. The case in question was Warner v. Ahmadi, which involved a seller trying to back out of a firm sale agreement, standing in stark contrast to many of the other cases we've covered on this channel, which mainly involved buyers trying to back out of their firm sale agreements. The decision from the court comes at a time when Ontario's real estate market is shifting downward very quickly, and many homeowners are starting to ask whether or not it's best to buy first and then sell, or to sell first and then buy. Indeed, gone are the days where homeowners can buy a property with the firm understanding that their own house will sell within a matter of days.
Why do you keep picking on me?
So what I want to do today is go over the case, take a look at the details and what the court ordered, and then take a look at the implications for home buyers and home sellers going forward. With the end of the month coming in just a few days, Canada's local real estate boards should be starting to release the data for the month of August, and we'll obviously have an update on this channel on that data. If you want to get those updates, make sure you click, like, and subscribe, but for now, let's get into this case. The case in question involved Wendy Warner, the buyer, and Maarouf Ahmadi, the home seller, who agreed to sell Warner his condo for $340,000 in August of 2021. After a number of extensions requested by Ahmadi, he failed to follow through with the sale of the property, citing a lack of spousal consent. Warner brought the case to court, and the judge ruled in favor of Warner, finding that the spouse did not actually interfere in the sale of the home. And then the judge granted specific performance, meaning the judge ordered Ahmadi to complete the sale of the home within 60 days. Indeed, the court upheld previous rulings on this issue, deeming that when one side does not fulfill their end of the contract, the other side is deemed to be the innocent party. The court wrote, where the other party wants to and can close the agreement, they are the innocent party to the transaction. While this might seem like an open and shut case, Ahmadi did not end up selling the home to Warner, as he is appealing the case. As such, Warner brought the case back to the court, asking for specific damages from Ahmadi for failure to complete the transaction. In addition to the ongoing legal and storage costs, Warner also argued that she can no longer get the mortgage rate that she could have gotten when she purchased the home, as rates have gone up from 3.84 to 4.505. The judge agreed with Warner and ordered Ahmadi to pay for her moving cost, legal cost, and storage costs up until the day of closing. The judge also ruled that Ahmadi would be on the hook for the difference in mortgage rates for the next 5 years. Further, the judge ordered that all of these costs are to be deducted from the $340,000 purchase price. These costs are ongoing as this case makes its way through the appeals court, so they could obviously very much add up over time. So, in summary, this is a case where the seller refused to sell after entering into a firm contract. The buyer brought the seller to court. The judge ruled in favor of the buyer, ordering the seller to sell and imposed costs for not doing so. So, in very much the same manner as we've talked about on this channel before, where the courts have held in favor of sellers when buyers try to back out of the agreement, they are also holding sellers accountable as well, enforcing the sale agreement and imposing costs when the seller tries to back out of that agreement.
It's a contract.
And this has big implications for home buyers who are trying to decide whether or not to sell first or buy first. If they sell their home first, but then are unable to buy a new home, are unable to find a new home, they still have to complete the sale of their current home, regardless of where they're going to stay thereafter. Absent a condition in the sale agreement saying that the sale is conditioned upon them finding a new home. And this is not that it can't be done. In a buyer's market, it happens all the time. But it has been a few years before home buyers had to worry about what happens if their homes do not sell. And the court is continuing to rule in the favor of the contract. Not so much in the favor of the sellers or the buyers. They are ruling in the favor of the contract. A firm sale agreement is a firm sale agreement, meaning it's very, very difficult to get out of that agreement without costs. So it's important for both buyers and sellers to understand the importance of conditions, and understanding what happens when an agreement to purchase is signed. While this case is currently under appeal from the lawyers I've spoken to, it could be a while before this makes its way through the courts, so there could be some time before we get a final decision on the matter, but we'll obviously have an update out on this decision when it comes out. If you want to get those updates, make sure you click like and subscribe, but for now, thanks so much for watching.